Strict liability represents a fundamental departure from traditional fault-based liability systems like negligence and intentional torts. In negligence, liability hinges on proving the defendant breached a duty of reasonable care. In intentional torts, we require proof of intent to cause harm or contact. Strict liability, however, imposes liability regardless of the defendant's state of mind or the level of care exercised. This means the plaintiff does not need to prove fault, no breach of duty, no intent required. The focus shifts entirely away from the defendant's conduct and onto two specific areas: either the inherently dangerous nature of the activity being undertaken, or the status of the defendant, such as owning a specific type of animal. If the elements of strict liability are met, the defendant is liable for resulting harm, even if they took every possible precaution. This concept ensures that those engaging in activities that pose unavoidable, high risks internalize the costs of potential injury, making it a crucial area for bar exam study. We established that strict liability focuses either on the nature of the activity or the status of the defendant. Let us now transition into the first major category: abnormally dangerous activities. These are not just activities that are somewhat risky. They are activities that, even when conducted with the utmost care and precision, still present a foreseeable and highly significant risk of serious harm to persons or property. Think of activities where the risk cannot be eliminated through reasonable care. The policy rationale underpinning strict liability for these activities is straightforward. We force the actor engaging in these high-risk, non-common activities to internalize the costs of any potential, unavoidable harm that results. If you choose to engage in something society deems inherently dangerous, you must bear the financial responsibility for the resulting damage, regardless of how careful you were. So, how do courts decide if an activity crosses the line from merely risky to legally, abnormally dangerous? The definitive guide for this determination comes from the Restatement Second of Torts, specifically Section 520. This section provides a multi-factor balancing test, meaning no single factor is determinative, but the totality points toward liability. The factors are crucial for bar exam success. First, we look at the high degree of risk involved. Second, the likelihood that if harm results, it will be great harm. Third, and perhaps most telling, is the inability to eliminate the risk by the exercise of reasonable care. If you can eliminate the risk through standard precautions, it is likely not abnormally dangerous. Fourth, consider the commonality of the activity in the community. Is it something everyone does? Fifth, the appropriateness of the activity to the location where it is carried on. Is storing explosives appropriate in a dense city center? Finally, the sixth factor weighs the value of the activity to the community against the risk posed. Remember these factors as the blueprint for identifying an abnormally dangerous activity. Now that we understand the 6 factors, let us look at the classic examples of abnormally dangerous activities that frequently appear on the bar exam. The most common example involves the use of high explosives, such as blasting operations, perhaps for construction or demolition. Another frequent scenario involves large-scale fumigation operations, especially those utilizing highly toxic gases in proximity to others. A third category covers the storage of massive quantities of volatile chemicals or flammable liquids. Crucially, remember the fifth factor: appropriateness to the location. Blasting might be acceptable in a remote quarry, but it becomes abnormally dangerous if attempted in a densely populated urban center. The activity itself must be unusual or inappropriate for the specific locale to trigger strict liability under this doctrine, regardless of the care taken. We have identified what constitutes an abnormally dangerous activity. However, Establishing that the activity meets the Section 520 criteria is only half the battle. Just like in negligence cases, the plaintiff must still satisfy the element of causation. Specifically, we are concerned with proximate cause. The critical inquiry here is whether the harm suffered by the plaintiff was of the very type that made the activity abnormally dangerous to begin with. For example, if blasting causes severe ground vibration damage to a neighboring structure, that damage falls squarely within the foreseeable risks associated with blasting, and strict liability applies. Conversely, imagine the blasting operation causes a sudden, unrelated power surge miles away, which then damages the plaintiff's sensitive computer equipment. In that scenario, the chain of proximate causation might be broken because the resulting injury is not the type of harm typically associated with the inherent danger of the explosive force or vibration. The scope of liability is limited to the risks that justify classifying the activity as abnormally dangerous. Now that we have thoroughly examined strict liability arising from abnormally dangerous activities, we shift our focus to the second major category where strict liability applies: liability stemming from animals. This area is divided based on the type of animal involved. We begin with wild animals, often referred to by the Latin term fere naturae. The rule here is remarkably straightforward and absolute. If a person keeps a wild animal, such as a tiger, a bear, or a venomous snake, the keeper is strictly liable for any injury that animal inflicts, provided that injury results from the dangerous propensities typical of that species. Crucially, the owner's care, training, or diligence is irrelevant. If your pet lion bites someone because lions naturally bite, you are liable. The law presumes that keeping such an animal inherently carries an unavoidable risk of harm stemming from its nature. This absolute liability contrasts sharply with how we treat domestic animals, which we will cover next. We now turn our attention from wild animals, or fere naturae, to their counterparts, domestic animals, known legally as mansutae naturae. This category includes common animals like dogs, cats, and cows. The standard for imposing strict liability here is significantly different and less absolute. For a domestic animal owner to be held strictly liable, the plaintiff must prove that the owner knew, or had reason to know, that this specific animal possessed a dangerous propensity that goes beyond the normal, expected behavior for that species. This concept is famously known as the one-bite rule. If a dog has never bitten anyone before, the owner is generally not strictly liable for the first bite, because biting is not considered a propensity beyond the norm for dogs generally. However, once the owner has notice, perhaps through a prior aggressive act, growl, or bite, the knowledge requirement is satisfied, and strict liability attaches for subsequent harm. It is vital to note that many modern statutes, particularly concerning dog bites, have superseded this common law rule, imposing strict liability regardless of prior knowledge. Having established the basis for imposing strict liability, we must now examine the defenses available to defendants in these strict liability actions, whether arising from abnormally dangerous activities or dangerous animals. The most potent defense available is assumption of risk. For this defense to succeed, the plaintiff must have knowingly and voluntarily encountered the specific risk created by the defendant's activity or animal. If the plaintiff knew the blasting operation was occurring nearby and chose to stand next to the site, they may have assumed the risk of vibration damage. Comparative fault, or contributory negligence, plays a much more limited role here. In pure strict liability cases, the plaintiff's ordinary negligence typically will not reduce the damages awarded, as fault is irrelevant to the initial imposition of liability. However, Some jurisdictions may allow comparative fault principles to apply if the plaintiff's negligence was a contributing factor to the injury, especially in cases involving domestic animals where knowledge, rather than pure activity risk, is the trigger. Remember, assumption of risk is the key defense to master. We have now covered the application of strict liability and the available defenses. To conclude our study for the bar exam, remember the overarching principle. Strict liability is imposed when the law determines that certain activities or possessions are simply too inherently risky for society to tolerate without forcing the actor to internalize the associated costs. This liability exists regardless of fault. We focused on two main pillars. First, abnormally dangerous activities, where liability hinges on a multi-factor analysis assessing the inherent, unavoidable risk of the activity itself. Second, animal liability, which draws a sharp distinction, absolute liability for wild animals, and knowledge-based liability for domestic animals that possess known dangerous tendencies. Master these two pillars and the policy rationale behind them, and you will be well prepared for any strict liability question on the exam.